5, 4, 3, 2, 1, start.
In the present writ petition, the challenge is to the order dated 25 August 2019 as well as the transfer order dated 3 September 2020 on the ground that the same is contrary to the transfer policy which was to be adhered to while effecting the transfers, and further the transfers have been effected on the basis of a notification which was circulated on 27 August 2020 subsequent to the transfer, which act on the part of the respondents is totally arbitrary and illegal, full stop. In the present petition, the decision of the respondent department dated 27 August 2021 is also under challenge on the ground that the said decision is not within the jurisdiction of the respondent department, as the same was liable to be taken by the government itself and not the department, keeping in view the provisions of the rules of business of the government of Haryana issued in the year 1977, full stop stanza. The petitioners are employees of the education department in the government of Haryana, have approached this court challenging their transfers, citing the discrepancies in the implementation of transfer policy which was to be adhered to while effecting the transfer, on the ground that the same has either been violated or the interpretation of the provisions of the policy on which the decision of the respondents to effect the transfer is based suffers from one or the other procedural defect, full stop. The first argument being raised by learned counsel for the petitioner to challenge the order of transfer is that as per the transfer policy of the year 2015 as amended on 2 June 2016, which has been made applicable for effecting the transfers were to be effected by evaluating the entitlement of a candidate qua the choice of posting as opted by the employees concerned, or marks which an employee could have got on the basis of certain aspects as envisaged in the said policy, full stop. An employee having higher marks was entitled for the option given by the said employee in preference to other employee having lesser marks, and in the present case the petitioners have been discriminated as the stations which have been opted by the petitioners who are working as TGT trained graduate teachers which is a state cadre, have been offered to the classical and vernacular teachers in short C and V who belongs to a district cadre, despite the fact that teachers have less marks in comparison to the petitioners, full stop stanza. Learned counsel for the petitioners argues that as per the policy, once a candidate having higher marks in entitled to the choice of posting as opted by him, offering the choice of stations opted by the petitioners to the C and V teachers despite they having lesser marks than the petitioners is not only contrary to the policy but causes prejudice the right of the petitioners to claim posting at a particular station, full stop. The said argument is to be dealt with keeping in view the rules governing the service, full stop. It is a conceded fact that as per 2012 rules which governs the service of the post of C and V teachers as well as the TGT C and V teachers is a district cadre, meaning thereby that they cannot be posted outside the district in which they have been appointed, full stop stanza. TGT teachers, that is the cadre to which the petitioners belong, is a state cadre and the petitioners can be posted anywhere in the state keeping in view the rules governing the service, full stop. That being so, the grievance of the petitioners as as recorded herein before needs to be evaluated by keeping in mind the said rules full stop. Once C and V teachers cannot be posted outside the district, the first preference of the posting had to be given to the said cadre, otherwise there will be no post to accommodate them within the cadre in case the posts are given to the TGT candidate having higher marks full stop. The said proposition, if not implemented, will create anomaly as then teachers will occupy a particular station in a district on the basis of the higher marks, and C and V teachers will have to be posted out of the district concerned to accommodate the choice of posting given by TGT teachers full stop. Once, as per the rules governing the service, C and V teachers cannot be posted outside the district in which they have been appointed. The transfer policy has to be operated in a manner that it remains in consonance with the rules governing the service. Hence, even if C and V teachers has lesser marks, he has to be given a preference over the TGT teachers with regard to the posting in a particular district. Otherwise, it will lead to a situation in which there might not be a post to accommodate C and V teachers in the district he is already working, keeping in view the fact that all the vacant posts in that district are allocated to TGT teachers, and there is also no other option with the department but to post C and V teachers outside the district concerned, which will amount to nullifying 2012 rules full stop stanza. Therefore, the grievance which is being raised by the petitioners qua the transfer policy that C and V teacher having lesser marks has been preferred over and above the petitioners who belong to TGT cadre cannot be accepted full stop. Further, grievance of the petitioners is that the said decision has been taken by the respondents after effecting the transfers full stop. There can be instances where while implementing a policy certain difficulties comes to the notice of the department and needs to be rectified so as to ensure that there is no anomaly which comes to into force by the implementation of the said policy, and implementation of transfer policy becomes in consonance with the rules governing the service full stop. Rules governing the service being on a higher pedestal are to be followed when compared to a transfer policy full stop. Hence, non-adhering of a provision of transfer policy so as to prevent violation of the statutory rules governing the service cannot be faulted with full stop. Further, prayer of the petitioners is that the decision dated 28 August 2021, which has been taken after the transfer of the petitioners, copy of which has been appended as Annexure P4, was beyond the jurisdiction of the department, as the same can only be taken by the government keeping in view the rules of the business of the government of Haryana issued in the year 1977, copy of which has been appended with this petition as Annexure P6 full stop. A bare perusal of the clause 15 of the Schedule 1, which is being relied upon, shows that the proposal involving any important change of policy or practice, the same will be dealt with by the government at its own level in accordance with the rules of business of the government of Haryana issued in the year 1977 full stop stanza. The said argument is to be tested by keeping in view certain facts full stop. The policy in question which needs to be changed or a practice which needs to be changed as required under the rules of business should be such policy or practice that it creates a right within a person who is claiming prejudice upon the change of the said policy or the practice full stop. For the said purpose, first it has to be adjudicated upon whether the transfer policy creates a right with an employee to claim the benefit under the said policy or not, full stop.